She has represented large and small businesses in all forums, federal and state courts, mediations, and arbitrations. Emily was named one of the top women attorneys in Minnesota last year and recognized as a Minnesota Rising Star from 2007 to 2013. Step carefully. Here to discuss some of the ethical landmines for in-house counsel and trial lawyers is Emily Rome.
Good afternoon. Thanks very much, Phil. All right, well, we're here. We're powering through the end of the day. I'm one of the last people standing between you and your weekend, so let's get through this together. We're here to talk about living by the rules. This is not a shock to you. This is what we do as lawyers. One of the things that I think is important, sorry about that. Inside and outside counsel, this is what we do. This means being up to speed. It means being open for discussion and having a compliance culture. I don't just mean that you're being an ethical and good person. I think that everybody in this room probably qualifies in that respect. What I mean also is being organized. And if you'll think about today, a lot of people have put, for example, Rule 1.7 up for discussion, but everyone's coming at it from different angles and in different parts of a case. And so I think it's taking the time to build into the deal that you're working on, the lawsuit that you're working on, or in your in-house culture, the time and the space for discussions of these tough issues. We've all been talking a lot about, and we live day to day, adapting to technology and how that's impacting the practice of law. It's impacting it in really every area, as you all know. I think it boils down to a number of things. Learning the language and the devices. We can't be insulated from that, as we just learned from Carolyn, and we'll learn more from Clarence, who's after me. We need to be both protecting our own data, but as you'll see, there are significant rules, and one of the things I'm going to talk about today is HIPAA. I know you're excited. Calm down. Protecting other people's data as well, and that there are significant rules and regulations that apply to that as well. Finally, of course, we're all overseeing other lawyers, our other staff, and increasingly, I think if you're in-house, different kinds of vendors, and so there are rules that apply there. As I just briefly mentioned, I'm going to talk about complying with HIPAA, and that's in part because there have been some new rules that were issued at the beginning of this year, compliance for which you need to be effectively compliant by September 23rd of this year, with some exceptions to that. And then we're just going to dip our toe into considering some conflicts of interest. Okay, HIPAA, Health Insurance Portability and Accountability Act of 1996. You're asking yourself, why are we talking about this now? It's 2013. As I alluded to briefly before, there was a rule change that stemmed from a 2009 act called the American Recovery and Reinvestment Act of 2009. Part of that act is called the high-tech portion of that act, and that stands for Health Information Technology for Economic and Clinical Health. It gave increased enforcement power for HIPAA to state attorneys general. It handed over some of that power to state attorney generals, and then it made a difference in the way that the privacy and security rules under HIPAA, how that was going to be applied. Okay, so now I've told you a little bit about the change. Let's step back. Some of us are familiar with HIPAA in our practice, and some just in our regular life. But let's start from a baseline so we're all on the same page. HIPAA applies to covered entities. That's a defined term. That's principally hospitals, pharmacies, and health insurers, health clearinghouses, things like that. It governs how covered entities deal with protected health information, and HIPAA was put into place as a federal framework to provide a federal floor for protection and use of protected health data, okay? It also governs how covered entities interact with what are called business associates. And those are the third parties that, again, are going to be working with a covered entity to do different things for the covered entity. Could be law firms, it could be an accountant business, it could be data processing and storage, it could be billing and claims processing. All those sorts of businesses can end up being business associates. And law firms are at the top of that list as Health and Human Services. That's the government entity, Health and Human Services, and the Office of Civil Rights. That's who enforces HIPAA, okay? Before this change in the law, here's how HIPAA went. Here's HIPAA. and the ability to enforce it. Here's the covered entity, and here's a business associate, like a law firm or some of those businesses I mentioned. The way, there was only direct enforcement and direct liability with a covered entity. The relationship between the covered entity and the business associate was contractual, called a BAA, Business Associate Agreement. The government and Congress found that inconvenient in their ability to enforce what they wanted to. They couldn't get to the business associates. It was only a contract breach there. So they rewrote the law. So that's the change in 2009 that's been worked up and is now going to be fully implemented by next month. What it does is makes business associates, including law firms, directly liable for violations of HIPAA. You're sitting there saying, okay, blah, 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 HIPAA, does this apply to me or not? How do I figure that out? Are you a business associate of a covered entity? If your firm or your business represents a covered entity directly, certainly you are, or work with them, or you work with a business associate of a covered entity, and your firm needs access to protected health information in order to do its job, then business associate status attaches. Period, end of story. You don't have to have a BAA, you just become a business associate, okay? All right, great. Why do I care about this? Because under the new rules, you have affirmative duties to keep private information, to set up particularized security systems for that, and breach notification requirements. I'm going to get a little bit more into the weeds in the next couple slides on this. But let me just highlight briefly what they are for you. The privacy rule governs the uses and disclosures of PHI, protected health information. Uses, when you hear that word under HIPAA, you should think internal use. So the things you're doing inside the law firm with PHI are governed by these new rules. It's not just disclosures to others, it's things you're doing internally. The security rule was developed to set a national standard to safeguard the confidentiality, integrity, and availability of electronic protected health information. The privacy rule, you're going to have to, either at your firm or in your business, if you haven't already, go and look at all of these rules specifically. The privacy rule is difficult and nuanced, and parts of it apply to business associates. The security rule is also difficult, but it applies straight up, the whole entire thing, to business associates. And that's important because there are a lot of duties and responsibilities then that business associates have. Breach notification, that's just what it sounds like. Why? And then you have the direct liability for what? Well, significant monetary penalties, and again, the state AGs have joined the game. And they are in it for damages, injunction, costs, and reasonable attorney's fees. And they can assert directly, bring claims in the state in which they operate and you operate against you. There is now a tiered penalty system based on your level of culpability. It used to be $100 or so around there per violation. That's now the floor, and it goes up to $50,000 per violation. It caps at $1.5 million, but that's only, don't be lulled by that very small cap of $1.5 million. That's only for identical violations, so you could have significantly greater fines than $1.5 million. HHS and the Office of Civil Rights are training up state AGs, as they should, to enforce this law. But what I'll tell you is they're holding trainings around the country. There are modules online to train up. And one of the very first entity that they mention when they're describing this new world order of business associates and how you have direct liability, what's the first name on the list? Law firms. Okay, what should we all be doing? First, you have to go to hhs.gov, and really you have to, or have someone in your organization, or hire a company, or have your HR, but you got to get into these privacy and security rules, assess your current state of compliance, and where are the gaps. Under privacy, as I said, this governs uses and disclosures. The problem with this, I think, for law firms is going to be it sets out what's called the minimum necessary standard. You can only use the minimum necessary amount of protected health information in order to do your job. That's, again, even inside the law firm. So there are a number of administrative rules that govern the way that you can use it, and that we're just all going to have to deal with. The security rule sets out administrative safeguards. It really puts it into three buckets: administrative safeguards, physical safeguards, and technical safeguards. Administrative policies and procedures, that's policies and procedures for accessing, principally, the electronic PHI. The physical part of it is removing it from old devices, whether that's hardware, whether that's servers. You all got this. So wonderful that Ed and Ellis gave these to everybody. Aren't these great? They've made it so much easier for us to travel and do our practice. Admit it, half of you have lost this one from this morning already. If somebody in your firm puts protected health information on this, like I do when I go to a mediation, and God forbid I lost it, that is a breach, and you have to notify Health and Human Services. You have to notify all affected individuals, and there are serious ramifications for any breach, loss, or misuse of protected health information. On the technical side of the security rule, you have to now have access control software, audit control software, and encryption. The breach notification piece of this is the breach. What they've done is say if it's less than 500 people whose data has been breached, you have to notify the affected person, and you have to notify Health and Human Services in an annual log that you submit to them. They then helpfully put that information on their website where they direct state attorneys general by state so that they can find everybody who've made breaches. If it's, God forbid, more than 500 people, you must notify all affected individuals, you must immediately notify Health and Human Services, and you must immediately notify prominent local media so that it can be broadcast in the area so as to protect the people from all sorts of harm that may come for people accessing their protected health information, their medical records, their billing records. That's going to have all sorts of sensitive information about them. As we think about this, again, this is just touching on it. I understand that. I'm just trying to, if you haven't heard about it already, it's just to try to get you thinking about it and to remind us all, really, what we need to be working on and thinking about. So it's reading the rules, look at where you're having gaps. Inventory the information. It's thinking about in your firm who uses protected health information, what sorts of lawyers, staff, where is it, how is it currently being, how is it flowing through our organization right now? Identifying the technical controls that are necessary. This is logging on, having to log in and having password protected. It's encryption, it's all of those things. There are very significant policy and sort of procedures, and you have to really document out how you comply with this. That's part of the rule. And so it's drafting a lot of policy documents to go with that, to have in your firm if something should happen. And then developing training programs. It's including it as an element of whatever training you do, for example, for incoming lawyers on an annual staff training basis. This is an important part and required part of the compliance. And then you have to assign someone responsibility for managing that. You have to designate a security officer, they're called, and someone who's monitoring how you are complying as a law firm. All right, so that's HIPAA. It's dipping a toe in. Time is short here. I'm now going to move on to the conflicts of interest. We've all talked a little bit already, several times during presentations, about Model Rule 1.7. Why am I raising it? I'm raising it because I think as we've all been talking a lot about electronic interconnectedness and the ease of access now to getting into huge piles of data, that back in the day when that didn't exist, somebody who was working, let's say in a sub of a parent, maybe didn't have access to that. But now, because that's all so much easier, I think 1.7 conflicts can come up in ways that are unanticipated, at least in our prior practice. And when you merge that with the complex and large entity structure that many of you are as companies, or that we work with as outside lawyers, I think that 1.7 really needs to be thought about, not just as a checkoff, but as something that you're repeatedly visiting when you have developments in a case or in your law department in your business. Just some baseline rules. When we're talking about a complex entity structure, probably okay, and not a 1.7 conflict if you're having a simultaneous representation of a parent and a wholly owned solvent sub with aligned interests. Okay, so when you're in litigation, you're thinking about this, and sometimes it's easier to see the markers when you need to revisit this, in my view, when there's litigation, because you find a big trove of documents that implicates another sub, or somebody has to be added. It's my, having worked with lots of in-house folks, I think that in-house, this is what you deal with all the time. People from different areas, businesses, the joint venture guys asking you a question, and it's just something that you're constantly analyzing. I think as we do that, the areas where we can know there's tough case law and adversity may develop, if there's a lack of common ownership in any of the entities that are simultaneously asking you to work with them. When you are or may become adverse, that's easy to say from up here, that sometimes develops quickly, but when there's negotiation between the entities, something, of course, to be aware of, and when there's insolvency, because then you're managing for the benefit of somebody else. What's clear is the need to consider other rules, 1.9, 1.10, and 113, which is certainly the Bible for in-house folks. But 1.10, I think we often overlook when you're thinking about people in an in-house context who are dealing with complex entity structure. The mobility of lawyers inside of a corporation, you can get imputed conflicts that put privilege at risk and disqualification at risk in-house, just like you can for outside lawyers. Because it's very clear under the model rules that when they talk about a law firm, that also means a legal department. So as we look at lawyers who are moving inside companies, to also be thinking of these issues. And again, I know that these are things that people deal with significantly in their day-to-day life, but I think when we think about mobility, technology, and complexity of entity structure, it just counsels for all of us to think about them repeatedly as we go through our daily work. Thanks very much for your time and your 20 minutes closer.